Here we try to correct some misconceptions about journalists' legal rights, because often journalists try to use those rights to coerce information or access from public relations practitioners. Written by Parkinson and Parkinson in the Public Relations Law and Supplemental Text. Today, I will be talking about Chapter 12 in our textbook, and it was over laws and applications. That this is what I'm going to be teaching you about today, and I am credible because I have read this chapter and I have also researched definitions for these terms. So I'm going to be teaching you some key terms today, and these key terms can be found in your textbook in Chapter 12. The first term is libel. It is a printed falsehood and slander that was an oral statement that's false. There's a little difference between the two, but the courts often use the word defamation to describe this now, and that is the second term. Defamation is any false statement about a person or organization that creates public hatred, contempt, ridicule, or inflicts injury of a reputation. The third is invasion of privacy. This is a legal concept dealing with intrusion into an individual's private life. It is a tort that allows the person whose privacy is invaded to file a lawsuit against the person intruding upon his or her privacy. That term comes from legaldictionary.net. The fourth one is photo release. This is a signed release on file if it wants to use any photographs or comments of its employees or any other individuals in publicity, sales, brochures, or advertising. If a photo of an employee is used in product publicity, there needs to be a signed release. I think I've signed one for my high school. I'm not sure. I think you probably have to sign one no matter what if you're in a commercial or anything. The fifth one is copyright. This is protection of creative work from unauthorized use. An example of this could be the Copyright Law of 1978, and that states that copyright protection subsists in the original works of the authorship fixed in any tangible medium of expression now known or later developed. So your work's always going to be covered by this law. The sixth one is fixed. This is when the work is sufficiently permanent or stable to permit it to be perceived, reproduced, or otherwise communicated. The seventh definition is fair use. That part of a copyrighted article may be quoted directly, but the quoted material must be brief in relation to the length of the original work. So, for example, only one paragraph of a 750-word article and up to 300 words in a long article, book, or chapter must complete attribution of the source be given regardless of the length of the quotation. If the passage is quoted verbatim, quotation marks must be used. My eighth definition is trademark. This is a word that I think a lot of us have heard before. This is a word, symbol, or slogan used singly or in combination that identifies a product's origin. Sports logos and team uniforms constitute one of the largest categories of registered trademarks. I know I definitely have some sports teams uniforms hanging in my closet, and I probably never knew that they were. The ninth definition is the Reed case. The Reed case is when the U.S. Supreme Court in 1989 set a lasting precedent that writers retain ownership of their work and that purchasers of it gain merely a license to reproduce the copied work. Under the Reed interpretation, ownership of a writer's work is subject to negotiation and contractual agreement. My 10th term is a licensing fee. This must be paid before anyone can use logos or commercial products for any promotions of any sort. My 11th term is the licensing letter. This is a trade publication that reports on licensing issues. Recently, it did announce that the Major League Baseball pocketed $2.75 billion. The NFL earned $2.7 billion. The National Basketball Association earned $1.75 billion, and the National Hockey League made $630 million in just selling merchandise. And the sale of college and universities trademarked goods is rapidly approaching that mark. So all the sports teams outfit that I have in my closet that I was talking about, I have somewhat contributed to that amount of money. The next term is the 3 basic guidelines that are regarding the use of trademarks. So the first one is that trademarks are proper adjectives and should be capitalized and followed with a generic noun or phrase. So an example could be Kleenex tissues or rollerblade skates. The second guideline is that trademarks should not be pluralized or used in the possessive form. American Express credit card is improper. Trademarks are never verbs. The client FedExed the package violates the rule. So I know we obviously think that FedExed is a verb, but it's not. So that is something that is very interesting. My 13th is a service mark. It's almost like a trademark, but it designates a service rather than a product or a logo. So the abbreviation for service mark is SM, but when it's in small letters, the symbol for it is just in a small circle and it's SM. But if it's the registration is pending, the SM will be used without a circle. The 14th term is misappropriation of personality, the unauthorized use of a name or likeness of a person in order to sell one's goods or services. A form of trademark infringement can also result from the use of unauthorized or well-known entertainers, professional athletes, and other public figures in an organization, publicity and advertising materials. The 15th term is right of publicity, which gives entertainers, athletes, and other celebrities the sole ability to cash in their fame. The legal right is loosely akin to trademark or copyright, and many states have made it a commercial asset that can be inherited by a celebrity's descendants. Legal protection also extends to the use of sound-alikes or lookalikes. The 16th term is the Federal Trade Commission. It is a federal agency that was established in 1914 that administers an antitrust and consumer protection legislation in pursuit of free and fair competition in the workplace. The Federal Trade Commission has jurisdiction to determine that advertisements are not deceptive and misleading. Public relations personnel should also know that the Commission has jurisdiction over the product of news releases and other forms of publicity, such as videos and brochures. So an example of the Federal Trade Commission complaint is the one filed against Kellogg for claiming that its frosted mini wheats were clinically shown to improve kids' attentiveness by nearly 20%. The commission was charged that the claim was deceptive and Kellogg pulled all the ads. The cereal maker also faced a class action lawsuit by consumers, which eventually settled for $4 million. It was also agreed to stick to statements such as, clinical studies have shown that kids who eat a filling breakfast like Frosted Flakes have an 11% better attentiveness in school than kids who skip breakfast. Another example could be that the Campbell Soup case raised an important aspect of Federal Trade Commission guidelines. The soup company claimed that its soups were low in fat and cholesterol. They were helping in fighting heart disease. What Campbell Soup didn't say was that the soup was high in sodium and could actually increase the risk of heart disease. And I actually ate some today, so that's very interesting. Although a publicized fact may be accurate itself, the Federal Trade Commission staff also considers the context or net impression received by consumers. In the Campbell's case, advertising, copywriters, and publicists also ignore the information about high sodium which placed an entirely new perspective on the health benefits of soup. I do remember when all of that was going on, because I was hearing about it in the news. My 17th term is the U.S. Securities and Exchange Commission. This is a large independent agency of the United States federal government, and it was created in the aftermath of the Wall Street crash in 1929. The primary purpose of the Security and Exchange Commission is to enforce the law against market manipulation. The next term is the Sarbanes-Oakley Act. This was made a law in 2002 as a result of Enron and WorldCom financial scandals. Although the Enron scandal alone cost investors an estimated $90 billion, the devastation was dwarfed by the 2009 collapse of banks, market valuation, and real estate prices, largely due to the regulatory failings combined with ruthless speculation akin to betting. The act failed to protect consumers. For public relations and investors relation professionals, investors relation professionals that the ignorance is no excuse before the law and should be an operating principle. The Federal Trade Commission, or FCC, refers to an independent U.S. government agency that oversees all interstate and international communications. The FCC historically licensed radio and television stations, allocating frequencies that ensure the public airwaves are used in public interest. Increasingly, the Commission oversees internet policy. The Federal Drug Administration, or the FDA, oversees the advertising and promotion of prescription drugs, over-the-counter medicines, and cosmetics. Under the FDA, any person who causes the misbranding of products through the dissemination of false and misleading information may be liable. Equal Employment Opportunity Commission is charged with ensuring that workers are not discriminated against on the basis of their own religion, ethnic background, gender, or even their English skills. So now that I have went through all these terms with you, we are now going to be playing a game. This game is, we're going to be playing a Kahoot, and the Kahoot is a game-based learning platform used as educational technologies in schools. Its learning games are called Kahoots. You've probably played them before. They're really popular, and they're all multiple choice or true and false questions. And it was created by Morten Versvik in 2012 in a joint project with the Norwegian University of Science and Technology. So we're going to play a little bit of this. Can you guys see the questions?
No.
Get ready.
You can't?
No.
Printed falsehood and slander was an oral statement that is false.
Fake news, defamation.
Libel and lies.
Just guess. Damn it.
Okay.
So did I.
You're on video, Ava.
Any false statement about a person that creates public hatred, contempt, or ridicule, or inflicts injury on reputation.
False statement.
Yes.
Yellow.
Damn it. You're gonna yell at them?
A legal concept
video.
dealing with intrusion into an individual's private life. There, we're getting better. Signed release on file for the photographers for photographs and comments of employees or other individuals on the product.
Oh, that's the wrong one.
Oh, okay. Let's see. Protection of creative work from unauthorized use. Uh-oh. The work is sufficiently permanent or stable to permit to be perceived, reproduced, or otherwise communicated.
Yep.
Oh, 4. Part of a copyrighted article may be quoted directly, but the material must be brief. Oh, who's getting that wrong?
Goldman.
Ava! Look at you!
You can actually see the
Is a word, symbol, or slogan used to sing something in combination that identifies the product's origin.
Oh, I got thrown off.
Come in here, Musty, then. Precedent that writers retain ownership of their work and that purchasers of it gain merely a license to reproduce. Oh,
I'm too good.
good. Go, Ava. Must be paid before anyone can use logos for commercials, products, and promotions. Oh,
I'm on the
Ava is still on
on the
it.
podium.
A trade publication that reports on licensing issues. Oh! Basic guidelines regarding the use of trademarks.
Oh my God, it was really easy.
All the above.
Bring.
Like a trademark, but it designates a service rather than a product or its logo. The unauthorized use of a name or likeness of a person in order to sell one's goods or services. Oh. Which gives entertainers, athletes, and other celebrities the sole ability to cash in on their fame.
I hope you can hear him.
We could do. Administers antitrust and consumer protection legislation in pursuit of free and fair competition in the marketplace.
It's in first.
I don't know. Avis. A large independent agency of the federal government created in the aftermath of the Wall Street crash in 1929. Yo! Musty's at third! Sarbanes-Oakley Act made a law in 2002 as a result of the Enron and WorldCom financial scandals.
I had the best dog. I had the best dog.
Uh-oh, Ava,
He's
got
coming
you
for
now.
you. The Federal Communications Commission refers to an independent U.S. government agency that oversees all communication.
Damn it.
Oh,
Didn't
sorry.
get it right. I got it right.
The FDA oversees the advertising and promotion of prescription drugs, over-the-counter medicines, and cosmetics.
The blue.
Equal Opportunity Commission is charged with ensuring that workers are not discriminated against. Ooh, fast responses. Let's see who won. Oh,
Brody, must have got that.
oh, who's this? There you go. Thank you for playing, guys. So now that we have played the Kahoot, just a little summary. I talked about the chapter 12 in our textbook, the laws and applications and terms that you just need to know if you're going to be working in public relations, or just they're really helpful in life to know. And then last but not least, I hoped you learned and you will benefit from all these terms that I discussed, and the game really helped you learn these terms in a fun way for any public relations career that you decide to pursue.